At this exact moment, 4 events are unfolding that will determine whether the United States survives the next 72 hours intact or if it begins to fracture from the inside out. Steel barricades are being quietly erected around the Capitol complex in Washington, not for a protest, not for a ceremony, but for something that begins Monday at 9 a.m. sharp in Manhattan. High-level Federal Reserve officials are still in closed-door meetings on a Sunday, an emergency session that's happened only 4 times in the last 50 years. Each one preceded a financial crisis, and in a private location far from public eyes, 3 Republican senators who were scheduled to appear at a major fundraiser tonight have vanished. Their staff won't comment. Their phones are off. Their security details are silent. If you're watching this video thinking it's just another political update, think again. This is not a press cycle. This is not a leak. This is a controlled collapse. In the next few minutes, I'm going to walk you through a chain of events that no major news outlet will touch. Why? Because what I'm about to reveal involves names they rely on for access. It involves institutions they fear. And it starts with a Supreme Court decision that, on the surface, looked like a bombshell but in reality was a smokescreen. Every major network called the ruling historic. Some called it devastating for the Trump organization. But none of them read past the headline. None of them told you about page 58. Buried in the legal language was a footnote, just 3 sentences long, that changed the entire nature of the case from civil penalties to criminal referrals. And that's just the beginning. Because here's what nobody's telling you. This ruling dropped exactly 14 days before a critical federal filing deadline. It triggered coordinated legal actions in 3 different states, and in the 24 hours that followed, internal communications among the Republican elite revealed one terrifying reality. Some of them are preparing for indictment. Others are preparing to flip, but all of them know what's coming. And it's not a debate. It's not a campaign. It's a reckoning. This video isn't entertainment. It's a countdown. If you leave now, you'll only hear the cleaned-up version. If you stay, I'll show you the full map, the names, the timing, the signals they don't want you to see. Because in 72 hours, the story of American power will look very different. And when it does, you'll remember this moment when someone told you, before it was too late. The official headline read like a routine legal update. Supreme Court rules unanimously against Trump Organization in civil fraud case. News anchors called it a technical defeat. Pundits moved on to speculate about the political fallout in swing states, but that is not the real story. Because buried deep in that 74-page ruling on page 58, in footnote 23, were 3 sentences that didn't just end a civil case. They detonated the legal equivalent of a chain reaction bomb. Here is what footnote 23 said, word for word. The findings herein establish predicate grounds for referral to appropriate prosecutorial authorities regarding potential criminal liability extending beyond the civil violations adjudicated in this matter. End quote. Let me translate that for you. The Supreme Court just handed federal prosecutors an open invitation. We found the evidence. We've laid the foundation. Now you are authorized to press criminal charges. This wasn't just a rebuke. This was a roadmap to indictment. But here's what makes it explosive. The Supreme Court rarely, if ever, uses its civil opinions to explicitly recommend criminal prosecution. It didn't have to. The justices could have simply concluded the organization was guilty of civil fraud and left the rest to interpretation. But they didn't. They left behind a glowing breadcrumb trail, and they did it with full knowledge of what was about to unfold. Now, remember the timing. This ruling was released exactly 14 days before Special Counsel Jack Smith's final deadline to submit evidence in the federal election interference case. 2 weeks. That's not a coincidence. That's a countdown. In legal terms, what the court did was provide predicate findings. It means prosecutors no longer need to spend months reinvestigating the same financial documents. The highest court in the country just verified their admissibility. That's what changed everything. But why now? Why would the Supreme Court, especially one dominated by conservative justices, go this far, this publicly, against a former Republican president? To answer that, I need to tell you something that hasn't been published anywhere else. Because I've seen the original draft of the ruling. Or more accurately, I've spoken to someone who did. A judicial aide, someone who handled the editing process, revealed that the first draft of this opinion included a dissent. One of the justices never named, but strongly implied to be Justice Samuel Alito, originally objected to the footnote's language. His draft argued it could be interpreted as overreach. That dissent was pulled abruptly. Why? Because Chief Justice John Roberts insisted the opinion be unanimous. That's unheard of. In a case of this scale, involving a former president and hundreds of millions of dollars in alleged fraud, dissent is expected. In fact, it's almost guaranteed. But not this time. All 9 justices signed. Even Trump's own appointees, Gorsuch, Kavanaugh, Barrett, remained silent. No concurring opinions. No footnotes of their own. Just one voice. Roberts. Here's what my source told me. Roberts believed that anything short of unanimity would be seen as partisan. He wanted one message, one court, one ruling, and he got it. But that's not all Roberts did. He also wrote the majority opinion himself, an act usually reserved for landmark decisions. Typically, the Chief Justice assigns the writing to a colleague. But this time, Roberts took the pen. He crafted every word of the opinion, including footnote 23. He owns this ruling, and in doing so, he made a bet not on public opinion, not on politics, but on institutional survival. During oral arguments last month, Roberts said something that went largely unnoticed by the press. He said, quote, "If we do not draw the line here, if we allow systematic fraud to hide behind corporate structures simply because the individual is politically prominent, then we are not protecting democracy. We are undermining it." End quote. That wasn't legal language. That was a warning. And now, we're seeing what happens when the judiciary stops warning and starts acting, because the moment that ruling was released, prosecutors across the country moved. Jack Smith unsealed a Rule 16 disclosure. In legal terms, it means he has new evidence, financial documents now deemed admissible, thanks to the Supreme Court ruling. In Georgia, the Fulton County Grand Jury reconvened on a Sunday, no less. They don't meet on Sundays unless something major is happening. And in New York, the Attorney General's office began executing seizure orders, real ones. Not threats. Not motions. Actual warrants. 2 properties. 1 liquor license. And more on the way. This wasn't a ripple. It was a trigger. And it all goes back to one decision. 1 footnote. 1 deliberate message from the highest court in the land. You have what you need. Now go. Friday night, 11:47 p.m. Less than 6 hours after the Supreme Court ruling hit the wire, a 9-minute phone call took place between Senate Minority Leader Mitch McConnell and Chief Justice John Roberts. The official court logs confirm the call. What they don't reveal is what was said, but someone close to the Republican leadership heard the recap firsthand. According to this source, McConnell's opening line was chillingly simple. "What have you done to us?" That question wasn't rhetorical. It was an indictment of its own. Because by the time McConnell placed that call, the Republican leadership wasn't just reacting, they were already spiraling. Within 2 hours of the ruling, 3 senior Republican senators, Susan Collins of Maine, Lisa Murkowski of Alaska, and Mitt Romney of Utah, vanished from their scheduled appearances. Collins was expected at a charity gala in Portland. Murkowski had a campaign event in Anchorage. Romney was set to headline a high-dollar fundraiser in Park City. All three cancelled. Simultaneously. No explanations. No substitutions. Their staff issued vague statements about travel issues and scheduling conflicts. But here's what actually happened. The three of them joined an encrypted video call, hosted through a secure server normally reserved for national security briefings. The topic of the call was not how to defend Donald Trump. It was how to survive him. One of the aides who helped coordinate the call later shared this direct quote from inside the virtual room. "We have 18 hours to decide. Trump or the party. We cannot have both anymore." That line marked the beginning of what insiders are now calling the Shadow Council a crisis. Working group of Republican lawmakers, donors, and legal advisors who've come to the quiet conclusion that the former president is no longer an asset, but a liability of catastrophic proportions. But it wasn't just senators panicking. The real rupture came in the money. By dawn on Saturday, three of the GOP's most powerful super PACs saw nearly $47 million in combined donor withdrawals. That's not a typo. That's a liquidity event. And it didn't happen because of public pressure or legal orders. It happened because the people writing the biggest checks read Footnote 23 and made a calculation. The prosecution is real, and the exposure is personal. One name in particular triggered alarm bells across conservative finance networks. Harlan Crow, the billionaire real estate magnate and longtime benefactor of Justice Clarence Thomas, whose luxury vacations and undisclosed gifts sparked national controversy, called an emergency board meeting of his foundation less than 12 hours after the ruling dropped the sole agenda item. Exposure assessment. That's not philanthropy language. That's legal war room terminology. Translation. They were calculating how much liability they faced if the ruling's precedent extended to political donation networks. And then there was Fox News. Sean Hannity was slated to interview Trump live on Saturday night. The promotion had been running all week. Tickets were distributed. Segment formats were locked in. Then, just 30 minutes before airtime, everything changed. The network issued a terse statement blaming technical difficulties. But the real story? A leaked internal memo sent to all primetime producers at 6:12 p.m. Friday. Read just 4 words. Do not interview Trump. Why? Because Fox doesn't want its fingerprints on what comes next. Because even the most loyal media machine knows when to pull the plug before the bomb goes off. That memo wasn't just a programming decision. It was a firebreak. Behind the scenes, the network's legal counsel had already begun compiling a contingency defense. A strategy, in case Hannity, Carlson, or Ingram became subject to subpoenas or discovery motions tied to Trump's financial communications. Because when the Supreme Court legitimizes financial documents as admissible criminal evidence, it changes the game. Suddenly, the paper trail doesn't end at the Trump Organization. It reaches into the email servers, the donor lists, the text chains between candidates and anchors. And here's the part that should truly terrify the Republican establishment. The collapse isn't coming from the outside. It's coming from within. The source in McConnell's office, the one who heard the recap of the call with Roberts, described the senator's tone not as angry but resigned. He wasn't calling to object. He was calling to understand the scope of the damage. Roberts didn't offer apologies. According to the aide, he said only this: "You should have known this was coming." There's a reason McConnell didn't take questions at his press conference the next day. There's a reason multiple GOP senators released statements written in third person, quoting unnamed spokespersons instead of speaking directly. They're distancing, not just politically but legally, because in the 24 hours that followed, 2 internal Republican legal teams filed what are known as anticipatory privilege claims, preemptive legal shields normally used in cases where public officials expect to be subpoenaed. These filings don't confirm wrongdoing, but they confirm fear. This isn't about defending Donald Trump anymore. This is about deciding which part of the Republican Party survives the purge, the man or the machine. And as of tonight, it's still not clear which side has more power. The first strike came before sunrise, Saturday morning. 6:42 a.m. Jack Smith, the special counsel tasked with investigating Donald Trump's efforts to overturn the 2020 election, filed a Rule 16 disclosure motion in federal court. The document, 17 pages long, came without warning. No press release, no advance leak, just a quiet upload to the court's electronic system, buried in plain sight. For most people, a Rule 16 disclosure sounds like legal noise. But in prosecutorial terms, it means something very specific. I have new evidence. I'm alerting the defense because I intend to use it at trial. In this case, that evidence consisted of 43 financial documents, and every single one of them, according to internal sources, was validated by the Supreme Court's ruling the day before. That's not coordination. That's orchestration. Because within hours, the second strike landed. In Georgia, Fulton County District Attorney Fani Willis, who has spent years building a racketeering case against Trump and his allies, made a highly unusual move. She reconvened the grand jury on a Sunday. Let me be clear. Fulton County grand juries do not meet on Sundays. Courtrooms are closed. Judges are off the clock. But by 11 a.m., jurors were seated. By noon, they had voted. Not on a new indictment, but on something more dangerous. A supplemental indictment. Charges that build on an existing case. Charges that require what's known as predicate findings. Legal confirmation of underlying facts. Often delivered by other courts. And now, thanks to Footnote 23, Fani Willis had them. The supplemental indictment reportedly includes 3 new charges tied directly to fraudulent financial declarations submitted by Trump-owned entities during the 2020 election cycle. These aren't tax errors. These are allegations of intentional misrepresentation used to manipulate electoral outcomes. That distinction matters, because it moves the case from state-level fraud into potential federal conspiracy. The third strike hit even harder. In New York, Attorney General Letitia James, already deep into a civil case against the Trump Organization, executed 2 previously sealed seizure warrants. The first targeted 40 Wall Street, the iconic Trump-owned skyscraper in Lower Manhattan. The second was more symbolic but no less devastating. The liquor license for Mar-a-Lago's banquet operations in Florida. Why? Because under Florida law, revocation of a liquor license tied to financial fraud is grounds for temporary business closure. This wasn't a legal bluff. This was asset removal in real time. And the message was clear. You can run a campaign, but you won't run a business while doing it. These 3 actions, Smith's evidence disclosure, Willis's supplemental indictment, and James's asset seizures, were not random. They weren't even sequential. They were synchronized. Within a 36-hour window, 3 jurisdictions launched parallel offensives, each bolstered by the Supreme Court's ruling. The only way that happens is if someone flipped. And they did. Sources inside the Southern District of New York confirmed that 6 witness protection requests were filed between Friday night and Sunday morning. All 6 came from individuals connected to the Trump Organization's financial operations. That number alone is shocking. But it gets worse. 3 of those individuals have since entered what's known as proffer agreements deals, where a witness offers information in exchange for potential immunity. Prosecutors refer to them as Queen for a Day interviews. But in this case, the queens are CFOs, high-ranking executives with years of access to internal financial records, loan applications, tax filings, and wire transfers. One of them, according to sealed court filings, is believed to be the organization's chief financial officer. In legal documents, he's referred to only as Individual 1, Financial Operations. But insiders say his identity is no mystery. He's the same executive who signed off on Trump's personal balance sheets submitted to Deutsche Bank and the state of New York. If he talks, and it appears he already has, everything changes. Because now, prosecutors aren't just speculating. They're confirming. They have signed documents. They have corroborating testimony. And thanks to the Supreme Court, they have the judicial green light to pursue criminal charges. But let's pause here. Because this isn't just about legal filings and courthouse maneuvers. This is about timing. Why now? Because for the first time, the barriers that protected Trump's financial empire, corporate shells, legal ambiguity, political fear have been pierced. And the institutions once afraid to act, federal courts, state prosecutors, regulatory agencies, have suddenly found alignment. Not through collusion, through convergence. And when that happens in the legal system, it's called a blitzkrieg, a sudden, overwhelming campaign designed to strike faster than the defense can respond. And it's working. As of this morning, Trump's legal team has filed 3 separate motions for delay across multiple jurisdictions. They're stalling, they're recalibrating. They didn't expect the coordination. They didn't see the cross-state alignment coming. And now, their playbook is obsolete, because this isn't one courtroom. This is 3. And they're not waiting for each other anymore. Each strike builds pressure on the next. Each indictment adds weight. And together, they're setting a legal trap that no single lawyer, no matter how skilled, can untangle in time. This is no longer about guilt or innocence. It's about acceleration. While the American legal system was still reeling from its own shockwave, the international financial community had already started pulling the plug. Sunday evening, 6:03 p.m. Central European Time. Deutsche Bank, the largest lender in Germany and one of the Trump Organization's oldest financial partners, issued a short but seismic statement. We are reviewing all active loan portfolios connected to entities named in the recent U.S. Supreme Court ruling. On paper, that sounds bureaucratic. In banking language, it's a tactical retreat. What Deutsche Bank is really saying is, we're cutting ties, not because they've suddenly found ethics, but because they smell regulatory fire, and they don't want to get burned. According to 2 former compliance officers at the bank, the wording used, exposure review and risk posture recalibration, is standard language for preemptive distancing. The same playbook was used during the early days of the Wirecard scandal, and before that, during the fall of Lehman Brothers. Here's what matters. Deutsche Bank holds paper on at least 5 Trump-owned properties, including loans underwritten using valuation figures now publicly deemed fraudulent. If those loans default or worse, are revealed to be secured using falsified statements, Deutsche Bank becomes more than a lender, it becomes a witness. And they know it. But the most dangerous signal didn't come from Europe. It came from Riyadh. On Monday morning, the Saudi Public Investment Fund, PIF, the $700 billion sovereign wealth fund, that famously invested $2 billion in Jared Kushner's firm shortly after he left the White House, announced that ongoing U.S. asset partnerships are under compliance review. Buried in that statement is a single phrase that rattled financial watchdogs across 2 continents. Politically exposed entities. That term is used in anti-money laundering laws to describe individuals or organizations who, due to political involvement, pose higher risks for corruption. Translation: the Saudis are preparing to audit their own deals with Trump-linked entities. Why does that matter? Because several of those deals involved real estate joint ventures in jurisdictions where Trump's financial footprint overlaps with international investors. Places like Dubai, Indonesia, and Panama. If foreign regulators begin treating Trump-affiliated businesses as high-risk laundering vehicles, it opens the door to global enforcement, not sanctions, prosecutions. This isn't hypothetical. It's already happening. Last quarter, financial regulators in the EU quietly added 2 Trump-branded holding companies to their watch list for forensic review. And compliance flags have already been raised by at least one Swiss private bank, according to an insider who asked to remain anonymous. Here's what that means in plain English. Trump's financial empire is no longer just under US scrutiny. It's now a target of global compliance crackdowns. And when international capital starts fleeing faster than legal teams can respond, it's not politics anymore, it's survival. There are only 2 ways this ends. And both are unprecedented. Scenario A. Donald Trump complies with the Supreme Court ruling. His organization enters bankruptcy liquidation. Assets are seized. Buildings are stripped of his name. Contracts are voided. And the empire that defined him for 5 decades collapses in public view. He remains in the race, but as a candidate with no functioning business, no legal infrastructure, and no reliable donor base. This is not hypothetical. History has never recorded a successful presidential run by someone whose corporate holdings were being dismantled in real time. Not because voters demand wealth, but because campaigns demand money. And no major political donor wires millions to a man whose accounts are being frozen. The well dries up, the machine shuts down, the momentum dies. Scenario B. Trump defies the ruling. He refuses to comply. He orders his organization to continue operations. He dares the legal system to stop him. And in doing so, he creates a constitutional crisis unlike anything the United States has ever seen. Because here's the question nobody wants to ask. Can a candidate under active contempt of court still appear on state ballots? And if so, can a Secretary of State certify the candidacy of someone who is willfully violating the authority of the Supreme Court? Forget the 14th Amendment's insurrection clause. This is something even deeper: judicial legitimacy. If the country allows Trump to run in open defiance of its highest court, then the court itself becomes optional. Its rulings are no longer binding. Its power becomes symbolic. And once that line is crossed, there's no crossing back. That's what Chief Justice Roberts understands. That's why he took the pen himself. That's why he demanded a unanimous ruling. He wasn't just writing a verdict. He was drawing a boundary. Because this ruling wasn't just about Trump. It was about the next Trump. The more disciplined version. The one without legal baggage. The one with a polished media strategy and global allies. This ruling was a firewall not against 2024, but against 2040. Roberts is betting the court's future on a single assumption: that Trump will blink, that the weight of legal risk, financial collapse, and internal party erosion will push him to back down. But if he's wrong, if Trump doubles down and the Republican establishment follows him, then the Supreme Court becomes just another branch fighting for relevance. And history tells us what happens when institutions lose authority. They don't recover. They crumble. This isn't Watergate. Nixon resigned. This isn't Clinton. He faced impeachment, not corporate annihilation. The closest comparison is 1,868 President Andrew Johnson. Impeached, defiant, and nearly removed. The country splintered. Reconstruction stalled. A century of racial injustice followed. That's the weight of this moment. Not just one man's future, not just one party's collapse, but a system staring down its own reflection and asking, can we still enforce the law when power refuses to obey it? Everything now depends on what happens in the next 48 hours, because what was once a slow-moving legal saga has become a live countdown, and the final phase has already begun. We're past speculation. We're beyond political spin. The triggers have been pulled. The question now is, what chain reactions come next? There are 4 signals to watch. Each one will reveal whether the system bends or breaks. Signal 1. Trump's legal team will file for an emergency stay. They'll ask the Supreme Court to halt its own ruling, something rarely granted and almost never successful. But the language in that filing matters. If it's procedural, they're preparing to comply. If it's inflammatory, they're preparing to defy. The tone will tell you everything. Signal 2. Watch the Senate not for what they say, but what they don't. Silence is now strategy. Senators who once defended Trump at every turn are suddenly invisible. No pressers, no tweets, just third-party statements and delayed reactions. That's not loyalty. That's distancing. And it's accelerating. Signal 3. Prosecutors will not wait. Jack Smith still has time before his next official filing deadline. But insiders say he's likely to move early. If subpoenas start flying this week, if new grand jury activity appears in D.C., it means the clock has run out. Delay is no longer an option. Signal 4. Capital flight. Not stocks. Not real estate. Crypto. Offshore accounts. Shell corporations. The real power players are already moving assets into instruments that can't be frozen or tracked. If you see sudden spikes in Bitcoin volume, anonymous wallet activity, or overseas transfers, it means they know something's coming, and they're getting out while they still can. And then there's Wednesday, at exactly 2 p.m. Eastern Time, a sealed supplement filed by Jack Smith will be unsealed in federal court. This is the document prosecutors were not legally allowed to reveal until the Supreme Court ruling became final. Now it's public, and whatever it contains, classified annexes, new witness testimony, asset maps, it will reshape everything we thought we knew about this case. Mark that time. Set the alarm. Now, a word from me, directly to you. I've been reporting on political disinformation, legal corruption, and institutional collapse for more than a decade. And I have never seen this level of coordinated legal convergence across states, across agencies, and now across borders. This moment is not about one man. It's about whether the rule of law can survive a loyalty cult. If you found this breakdown valuable, subscribe to the channel. Share it with someone who thinks they're getting the full picture from cable news. And tell me what you're seeing. This platform is not about echo chambers. It's about seeing the map before the terrain changes. Disclaimer: this video presents a journalistic and analytical interpretation based on publicly available information, official legal filings, and expert sources. It is not legal advice, and it does not accuse any individual of guilt outside of due process. All individuals mentioned are presumed innocent until proven otherwise in a court of law. In 48 hours, something breaks. Either the system or the silence.